Welcome to the law offices of Chris M. Ingram podcast. We are excited to talk about the K-3, conditional resident, and immediate relative visa processes.
That's right. These are really key visa pathways designed to help U.S. citizens bring their non-American spouses home.
And this is a two-part series, so let's dive into part 2. If you truly appreciate these podcasts, it's essential that you like, follow, subscribe, and leave a comment, as this greatly boosts the channel's reach.
It really does help us out. Thank you so much for taking the time to do this. It means a great deal to us.
We would like to acknowledge attorney Chris Ingram and his dedicated legal team. They did a great job researching and preparing this material for us, and they would love to work with you.
Absolutely. And just a quick note, disclaimer. Please note that this podcast should not be regarded as providing legal advice specific to your situation. To schedule a complimentary consultation, please visit www.breakthroughusa.com.
We are thrilled to be able to present this topic for you today. Okay, so we're back.
We are.
And in this deep dive, we're, really trying to cut through the complexity of uniting U.S. families. We found out in our previous discussion that the K-3 visa, it's essentially obsolete.
Pretty much, yeah. Only 6 were issued in 2023. It just doesn't make sense anymore.
Yeah.
Because the conditional resident, or CR, and immediate relative, IR, visas are simply faster.
And more reliable, it sounds like.
Way more reliable.
Yeah.
That's the key takeaway right there. CR and IR visas saw over 88,000 issuances last year. That's huge. They are the standard pathway now.
Right.
So our mission today is to walk you through that standard pathway, step by step. We'll focus on the strategic moves you need to make, how to avoid those delays, and how to successfully pass what our legal team calls the love test, the consular interview.
Okay, the love test. Let's unpack this journey then. If you're a U.S. citizen married to a non-citizen, this whole thing kicks off right here in the U.S., doesn't it, with that initial petition?
Exactly. It all starts with filing Form I-130 with USCIS. That's the U.S. Citizenship and Immigration Services.
Right.
And this is basically the government's formal recognition of your marriage. But, and this is important, it's more than just filling out a form. It's really your first and maybe best chance to prove their marriage is real.
And based on attorney Chris Ingram's research, this is where couples can sometimes, get bogged down, right? What does robust documentation actually mean at this stage? What are we talking about?
Yeah, good question. We're looking for solid evidence that you've, commingled your lives. Think joint bank accounts, shared leases or mortgages, maybe joint insurance policies,
Right.
photographs that span the relationship, not just wedding photos. And those detailed communication logs like dated WhatsApp chats, text messages, emails, stuff that shows an ongoing relationship.
So the goal is to leave no doubt.
Precisely.
Yeah.
Make it impossible for USCIS to question the marriage's validity.
And our attorneys always stress the value of, surgical precision here, because the penalty for getting it wrong or being sloppy can be pretty harsh. About requests for evidence, the RFE.
The RFE. It's the enemy of timely processing, truly. It easily adds a 2 to 4 month delay to your case.
Wow, 2 to 4 months.
Yeah, and that's agonizing when you're separated from your spouse. So a really well-organized front-loaded application, it saves time, money, and a significant amount of emotional stress down the line.
Okay, so you get the I-130 filed, hopefully avoid an RFE. Once that petition is approved, what's the typical time frame?
Usually about 6 to 9 months, though it can vary.
Right. So after that approval, the case then moves over to the National Visa Center, the NVC. What's the shift in focus there?
So USCIS was about proving the relationship is real, the NVC. The focus shifts mainly to proving the U.S. sponsor is financially capable of supporting the intending immigrant.
Ah, the money part.
Exactly. You submit civil documents, things like passports, birth certificates, but the real star of the show at the NVC stage is Form I-864, the Affidavit of Support. This is where the U.S. citizen petitioner has to demonstrate they can support their spouse financially. The standard is usually 125% above the federal poverty guidelines for their household size.
And the NVC can also ask for more evidence if things aren't quite right.
Oh, definitely. If documents are missing, expired, or maybe not translated correctly, the NVC will flag it, which again causes delays. Precision matters here too.
Okay, so let's say the NVC paperwork is all good. We're moving towards the finish line. The final big step is the consular interview, right?
That's it. The foreign spouse attends an interview at a U.S. consulate or embassy in their home country. They need to bring all the original documents submitted previously, plus potentially more evidence.
And if all goes well, they get the visa stamp in their passport.
Correct. That visa allows them to enter the U.S. as a permanent resident. The physical green card usually arrives in the mail a few weeks after entry.
But before we get too far ahead, let's clarify that key difference we mentioned earlier, the CR versus the IR visa. It affects what happens after they arrive.
Yes, this is critical to understand. The immediate relative, or IR, visa specifically the IR-1, is what you get if your marriage is 2 years old or more at the time the visa is approved.
2 years or more.
Right. And the big advantage here is you get a standard 10-year green card pretty much right away after entering the U.S. No conditions attached initially.
Okay, that sounds ideal. But what if the marriage is newer, less than 2 years old when that visa gets approved?
Then you get the conditional resident, or CR, visa the CR-1. This means you enter the U.S. as a permanent resident, but you receive a green card that's only valid for 2 years. It's conditional.
Conditional. So there's another step involved later.
Exactly. There's one more hurdle. You have to file Form I-751, petition to remove conditions on residence. And you have to do this within the 90-day window before that 2-year conditional green card expires.
90 days before it expires. Got it. And what does that involve?
Yeah.
More proof.
Pretty much, yeah. You're essentially repeating the process of proving the marriage is ongoing and genuine. You submit updated proof, new joint leases, recent utility bills in both names, maybe joint bank statements from the time you've been in the U.S., recent family photos, affidavits from friends.
So more documentation to show you're still a real couple.
That's the idea. If USCIS approves the I-751, then the condition is removed, and the spouse gets the standard 10-year green card.
Okay, that makes sense. So the overall timeline, if everything goes, let's say, reasonably smoothly, you're looking at roughly 9 to 15 months from filing the I-130 to visa approval.
That's a typical range, yes. But it can definitely vary based on USCIS and NBC workloads, and also country-specific factors at the consulate level.
Which is why, as attorney Chris Ingram often emphasizes, meticulous preparation at every step ensures a smooth journey.
Absolutely. Preparation isn't just helpful. It's your primary defense against those frustrating bureaucratic delays.
Okay, let's talk about what you call the love test, the consular interview. This really feels like the emotional and strategic peak of the whole thing. The officer is basically a relationship detective.
That's a good way to put it. They're trained to look beyond the paperwork. They ask detailed questions, sometimes very personal ones.
Like what? Give us some example.
Oh, things like, how did you meet? Describe your wedding day. What side of the bed does your spouse sleep on? What are their hobbies? What did you do last weekend together? Even if you're apart, what did you talk about yesterday?
Wow. They really grill you.
They do. They're looking for consistency in your answers, but also for the unscripted details, the shared memories that only two people genuinely living a life together or building one would know.
And you mentioned some marriages face tougher scrutiny.
Yes, marriages that are very recent when the petition is filed, or those with significant age gaps, or big cultural or religious differences, or even where maybe one partner was previously divorced. These often face much deeper, more probing questions.
It sounds incredibly nerve-wracking, I can only imagine. So, beyond bringing all the required original documents, what's the best preparation strategy? What does the legal research from Chris Ingram's team suggest?
Well, our attorneys rely heavily on doing mock interviews with the clients. Practice helps build confidence.
Sure.
You need to anticipate the kinds of invasive questions that might make you stumble or second-guess yourself. It's also vital to bring supplementary evidence to the interview itself. Things like updated social media posts showing you together, phone records, travel itineraries from visits.
Kind of like a visual timeline.
Exactly. It backs up your story visually, as Chris M. Ingram puts it. The interview is your chance to shine. We equip you with the evidence and confidence to succeed.
You know, this next part I find really interesting. It highlights that immigration isn't just about following rules. You need cultural literacy, too. Let's talk about regional considerations, like take Mexico, specifically the U.S. consulate in Ciudad Juarez.
Right. Ciudad Juarez is one of the busiest consulates in the world for immigrant visas. They process thousands of interviews. The upside is they often schedule relatively quickly compared to some other posts.
But the interviews are tough.
They can be very intense, yes. High volume means they're very efficient, but also very focused on fraud detection. The strategic insight here from our team's experience is that your evidence needs to make sense both culturally and legally.
Oh, so?
Well, for instance, large family gatherings are a huge part of Mexican culture. Documenting those photos with extended family, letters from family members can be powerful, but you still need the standard U.S. proof, like joint finances. You have to kind of translate your cultural life into compelling legal proof.
That makes sense. And what about somewhere like India? You mentioned Mumbai and New Delhi. There, the scrutiny might focus on different things.
Yeah, in India, consulates are very familiar with arranged marriages, which are common, especially in Hindu traditions. But officers might still scrutinize them or long-distance relationships before marriage.
You finally got your family together on a H-1B. Your American dream begins. Your employer files for your EB-2 green card, but the wait is over 11 years. As the years go by, frustration grows, and now the company is talking about layoffs. This could be the end of your American dream. You search for help, but luckily, you land on breakthroughusa.com. They listen, reassured you, and built your EB-1 case with precision. Then one day, a notification buzzes, EB-1 approved. With your EB-1 green card, your entire family can breathe.
I have got my visa. I got my visa.
That's why the law offices of Chris M. Ingram is trusted. Your future shouldn't wait. Let's talk EB-1.
What are the next steps?
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
So how do couples handle that?
Proactively. If you're in an arranged union, our attorneys advise compiling evidence that explains this cultural practice to the U.S. officers who might not understand it intuitively.
Like what kind of evidence?
Maybe letters from family elders explaining the tradition and their involvement, photos from specific pre-wedding or wedding ceremonies, like Vedic rituals that are culturally significant.
Showing the process.
Exactly, and showing ongoing shared life. For example, our team often suggests including detailed photos from celebrating festivals together, like Diwali. It shows shared participation in cultural traditions and helps officers see the relationship within its proper cultural context, rather than misinterpreting customs as red flags.
That proactive cultural explanation seems really crucial. Okay, let's pivot to some common operational hurdles, the things that trip people up most often, starting with probably the biggest one, proving the marriage is genuine or bona fide.
Yes, this is the core issue. The biggest mistake we see is simply not providing enough convincing evidence. Officers are trained to look for red flags, maybe a very short courtship before marriage, limited time spent physically together, lack of shared finances or residence.
So what's the solution? Just more paper?
It's about the quality and type of paper. Integrate your lives as much as possible, as soon as possible. Get joint bank accounts, put both names on the lease or utility bills, get joint insurance policies, file taxes jointly if possible, share event tickets, travel stubs, build that paper trail of a genuinely shared life.
Okay, comprehensive evidence. Challenge number 2 is something everyone worries about in immigration. Delays. USCIS backlogs, slow NVC processing. It can add months.
Easily. Delays are frustratingly common. The primary solution here goes back to what we discussed. Thorough, perfect submission from the start. Minimize that RFE risk. Double-check everything. Now, for genuinely urgent life or death situations like a severe medical emergency, for either spouse, our legal team can guide couples on requesting expedited processing. But the bar for that is very high. It's reserved for truly dire circumstances.
So not just because you miss each other, unfortunately.
Unfortunately, no. Standard delays usually don't qualify for an expedite.
Okay. And the third common challenge, that financial requirement. Form I-864. What happens if the U.S. citizen sponsor just doesn't earn enough to meet that 125% poverty guideline?
Yeah, that's a common issue, especially maybe for students, younger people, or folks with fluctuating income like freelancers.
So are they stuck?
Not necessarily. There's a strategic solution. Using a joint sponsor.
A joint sponsor, who can that be?
It can be another U.S. citizen or a lawful permanent resident, often a family member, like a parent or sibling, but it could be a friend too. They need to meet the income requirement themselves and agree to be financially responsible for the immigrant spouse alongside the main petitioner.
So it's like a co-signer.
Essentially, yes. They file their own I-864. It's a crucial workaround for many couples. As attorney Chris Ingram often reassures clients, no obstacle is insurmountable with the right strategy.
Okay, these strategies are great in theory. Let's bring it all to life. Can you walk us through a couple of specific scenarios based on the research? Maybe start with Anna and Michael, who went for the conditional resident visa.
Sure. So Anna is from Mexico. Michael's a U.S. citizen. They had about an 18-month courtship before getting married. Now, crucially, based on our attorney's advice, they decided to skip the K-3 visa entirely.
Because of those terrible refusal rates we talked about last time?
Exactly. High refusal rates, slow processing.
Mm-hmm.
It just wasn't worth it. They went straight for the CR-1 path by filing the I-130.
Okay, so what was their strategy with the I-130?
Precision. Michael filed it with strong core evidence. Joint travel itineraries from their visits, photos, letters from Anna's parents supporting the union. But our legal team went a step further. They added detailed dated WhatsApp chat logs right from the beginning. The idea was to proactively counter any potential NVC or consular questions about the relatively recent marriage.
Mm-hmm.
Showed the depth of communication.
Smart. And what happened at Anna's interview in Ciudad Juarez?
Well, the officer did focus on one point.
Right.
There was about a 10-year age gap between Michael's parents and Anna's parents. It sounds minor, but the officer probed it as a potential cultural friction point.
Interesting. How did she handle it?
Because they'd prepared with mock interviews, Anna was ready. She explained the family dynamics confidently. They had also prepared a short video montage showing their life together, visits, family time. It helped visually bridge that perceived gap.
And there is...
Approved. The whole process took about 11 months from filing the I-130. Since their marriage was under 2 years at approval, Anna received the CR-1 visa and entered on the 2-year conditional green card.
Great outcome. Okay, scenario 2. Maya and Manjeet. This was for an immediate relative visa, involved an arranged marriage and some financial issues.
That's right. Maya is from India. Manjeet is a U.S. citizen. They had an arranged Hindu marriage about 3 years before they started the process. Because the marriage was over 2 years old, they were aiming for the IR-1 visa.
Okay. What were their hurdles?
2 main things. First, Manjeet's income was primarily from freelance work, and it fluctuated, falling short of the I-864 requirement at that time. Second, they got hit with a processing delay at USCIS. Their I-130 took about 9 months just for the initial approval.
So, financial issues and delays. How did the legal team strategize?
Okay, twofold. For the financial hurdle, our attorneys immediately suggested using a joint sponsor. Manjeet's brother, who had stable income, agreed to step in and file an I-864. That solved the income problem.
Good. And the evidence, especially with the arranged marriage aspect.
The evidence package was heavily tailored. They included letters from both families explaining the cultural context and process of their arranged marriage. They also provided extensive Skype and call logs to prove the depth and continuity of their relationship, despite the distance before Maya could immigrate.
Addressing the potential scrutiny head-on.
Exactly. And for Maya's interview in Mumbai, she came prepared. She actually brought a scrapbook.
A scrapbook?
Yeah, filled with photos of them visiting temples together during Manjeet's trips to India, participating in shared religious and cultural rituals. It was a powerful way to illustrate their shared life and commitment within their cultural framework.
That's brilliant. And the outcome for them?
Success again. Despite the initial USCIS delay, they navigated the NVC stage smoothly with the joint sponsor, and Maya nailed the interview. They got the approval about 14 months after filing. And because the marriage was over 2 years old, Maya received the IR-1 visa and got the full 10-year green card upon arrival.
These stories really drive home not just the strategy, but also the immense emotional toll this whole process takes. The separation, the anxiety, waiting for news.
Absolutely. It's incredibly stressful. The long-distance separation, the uncertainty, the feeling of your life being on hold, that's why the preparation isn't just legal paperwork. It has to include emotional support, too.
How does that work in practice?
Well, when our team talks about strategy, it includes providing compassionate guidance, setting realistic expectations, giving regular, clear case updates so clients aren't left in the dark. It's about helping them maintain focus and, importantly, hope throughout what can be a very tough journey.
That support structure sounds vital. Okay, so to kind of summarize our deep dive for you, the listener, the takeaway is that the CR and IR visas are definitely the reliable, strategic paths for spouses today. The K-3, not so much.
Right. And success in this journey, as we saw with Anna and Michael and Maya and Manjeet, it really hinges on more than just checking boxes. It's about using tailored strategies.
Strategies that anticipate the specific hurdles you might face. Cultural questions, financial requirements, potential delays.
Exactly. And proactively building a case to overcome them. It's about being prepared at every single stage.
Immigration really is fundamentally about planning for the future, isn't it?
It is. And we'll leave you with a final thought on that journey from attorney Chris M. Ingram. Immigration is about building a future together.
That's a great way to put it. We encourage you to consider how that kind of strategic, focused preparation can transform what seems like a complex, daunting, bureaucratic process into, well, a shared, beautiful vision of reality. Your future together.
Thank you so much for being with us today. We really hope you gained a lot from this discussion. Please subscribe to or follow this channel, as it can significantly increase the reach of this podcast and help us help more people.
Yeah, we'd greatly appreciate your support. And leave us a comment if you can. Let us know what you think or what else you'd like to hear about.
Also, follow us on YouTube, LinkedIn, Facebook, X, and Instagram. We're growing rapidly on those platforms thanks to our fantastic social media team.
We would also like to once again thank attorney Chris Ingram and his dedicated team for preparing all this research and material for our presentation today.
Absolutely. Their insights are invaluable.
And if you, or perhaps a friend or a family member, might need some help with their own immigration journey and would like a free consultation, you can visit our website.
That's www.breakthroughusa.com. You can schedule an appointment right there.
We'd love to hear from you and help you if we possibly can.
Bye for now.